My name is Stephanie Spiers, and I'm Counsel of Program Development here at the Law Society. And it's my pleasure to welcome you to our program this afternoon, first in a two-part series, the Business Bootcamp series. And this one is titled, Helping Your Client Choose the Best Business Structure, Making Sense of the Options. So welcome to those of you here in Toronto, as well as our viewers in London, Ottawa, Thunder Bay, and Waterloo. A couple of announcements before I introduce our speakers. If you have a cell phone on you, please remember to turn it off or set it to vibrate. You'll find in the materials an evaluation form. And as we undertake our interactive learning and try some new formats like this particular program, it's very important to us and we greatly appreciate your feedback. So please take the time to fill that out as the program goes along this afternoon and hand it in at the end of the program. And if you're watching via ILN, please fax it back to us. There's information on the form, a fax number. That would be very helpful. We appreciate it. Also, in Toronto, we do videotape, so just so you know that your voice or image may be captured on videotape in Toronto. For those of you in our locations, please remember to check off your name in the sign-in sheet, on the sign-in sheet. And I want to just quickly explain to you the format of today's program, if you want to refer to the agenda quickly. After a brief introduction from the Bootcamp Series Chair, Mr. Rob Hyndman, we'll be hearing from each of the presenters, and then we'll be going to take up the 4 hypothetical problems that appear at tab 4 of the materials. If you haven't had a chance to look at those, you'll have a chance at the dinner break. So there will be a light dinner for you at the dinner break of 15 minutes, and then from 6:05 to 6:45 we'll have the hypotheticals. We'll have some interaction with the audience, both here in Toronto and then towards the end of that session with our other sites, and then we'll move to a Q&A session. Just a note on ILN, you may experience a momentary muting when the operator checks into your site if you're watching from ILN, so just please bear with that. Finally, I would like to thank Rob Hyndman, who's the chair of the Business Bootcamp series, and all of our presenters today, Gerald Courage, Wayne Gray, and David Steele, for their hard work in putting together today's program. I'll do some brief introductions, but I'll also refer you to the biographical materials which are at the front of your binder. Mr. Hyndman practices in the area of corporate and commercial law at Ogilvy Renault, where he's a partner, including advising private and public companies on acquisitions, divestitures, license, distribution, and supply agreements, strategic alliances, shareholders agreements, and other commercial contracts and transactions. So he's got a very broad practice base, and he's got lots of experience with lecturing and teaching here at the Law Society and elsewhere. I'll refer you to his biography. Sitting to Mr. Hyndman's on my far right, and to his left is Wayne Gray, who's a partner at Macmillan Binch. He has extensive experience acting for both domestic and international private sector companies in a wide range of distribution, manufacturing, and high-tech sectors. So he has a diverse corporate commercial practice. He's also the author of several books, and I'll leave you to look at that in his biography. Next to Mr. Gray is Mr. Gerald Courage, whose practice focuses in tax law, where he's a partner at Miller Thomson. His taxation practice encompasses the full range of tax and related matters with a principal emphasis on corporate tax. And he has particular expertise in the tax aspects of corporate reorganizations, mergers and acquisitions, corporate finance, and business succession planning. So finally, Mr. Steele is on my left, and he is a partner Mr. Steele's a partner at Torys, and he has practices in the area of pensions and benefits, private client tax and estate planning, and trusts and estate. He's also currently the director of a new master's program in the law of trusts at Osgoode Hall, and I refer you to his biography as well for extensive information. At this point, so we can get the show on the road, I will turn the microphone over to Rob Hyndman to discuss with you the program.
Thanks, everybody, for coming out on a blustery afternoon. As Stephanie said, I'm the chair of the program. We've called it Business Bootcamp, Essential Training for Every Business Lawyer. And we're starting off first 2 sessions, the first one today, which is essentially about structuring, the next session in about 2 weeks, which concerns purchase and sale of a business. Now, after those sessions, beginning in the fall, and then we believe running into next year, we'll be continuing the series and presenting an additional series of CLE sessions. The common theme for all of this is a practical, hands-on approach to teaching essentially the fundamentals of business law. These sessions, the session today, in 2 weeks, and through the fall and next year, are designed to focus on the why and the how of business law challenges. One of the themes that we've tried to pay attention to is to draw the connections between a formal legal training and the practical problems that face lawyers as they navigate their way through mandates. We are going to try to avoid the presentation of precedent as gospel and focus instead on understanding why common or favored approaches have developed as they have, and the practicalities of how to analyze problems and implement solutions. Now, for the fall and for next year, because business lawyers work so often at the intersection of more specialized areas of law, what we'll be focusing on is introducing sessions that pay particular attention to some of those specializations and how they intersect the business lawyer's practice: IT, IP, banking, tax, financing, and the like. We also plan to approach these topics with what we believe will be a very novel case files approach that will extend the practical approach you'll see today and will get more deeply into the method of working with hypothetical scenarios and getting students, the attendees, actively involved in a discussion of the problems that scenarios present and how to solve those problems. Today, however, we're going to start with an exploration of what can, in many cases, be the most interesting, abstract, and intellectually stimulating tasks for the business lawyer, helping the client choose the optimal business structure. These are skills that are fundamental to what we do, but very often they are simply not developed beyond the introductory approach that is taken in most law schools to describing incorporation and the implications of incorporation, carrying on a business as a partnership, and sole proprietorship. We'll go a lot further than that today. So without further ado, I'd like to introduce the first presenter, Wayne Gray of McMillan Bench. Thank you, everybody, for coming.
Okay, oops, to the end. Okay, thanks. Okay, thanks. Sorry about that. So I'll be talking about the commercial law aspects of various business vehicles. There are obviously commercial aspects and tax aspects have to be dealt with together because the choice of business vehicle will have a great deal to do with the tax aspects that the clients are receiving, and so therefore the tax aspects end up driving the choice of the business vehicle. But it's important to also understand a lot of the commercial law differences between them. Just to give you some idea before we get started into looking at the business vehicles, this is a very important part of lawyering, choosing a business vehicle. The volume of business formation in Ontario, last fiscal year for Ontario, which is March 31, 2003, there were about 49,000 Ontario corporations formed, new ones. About 8,200 federal corporations formed out of Ontario for a total of about 57,000 and change. That doesn't include any of the corporations formed under the Ontario Corporations Act, the Federal Corporations Act, or the laws of other provinces and states that are doing business here. And of course, there's a lot more than that because of there's partnerships, divisions, joint ventures, co-ownerships, business trusts, all of which there's no statistics available, but we think that there is a great deal more than the 57,000 that we've mentioned. because not all partnerships and general partnerships, joint ventures and co-ownerships are required to register upon formation. The landscape with respect to business vehicles has changed a great deal in the last few years. While corporations are still the main driver of the economy, but they represent about 86% of the private output in the U.S. In both countries, there is a wider spectrum of choice available now than ever before. 10 years ago, acronyms such as the Limited Liability Company, Limited Liability Partnership, ULC, and NSULC were not widely known in Ontario. Professional corporations didn't exist in Ontario. The income trust as we know it today did not exist then. And today the limited partnership, contrasting 10 years ago to today, the limited liability partnership has largely taken over the firm practice of law and accounting. The Nova Scotia Unlimited Liability Company has become the vehicle of choice for large dollar U.S. investment in Canada. And of course, the income trust has become the hottest vehicle in Canadian capital markets. So a lot has changed. The paper that is in part of the materials looks at the tax and commercial law characteristics of the different business vehicles from the perspective of each separate business vehicle. What my presentation and Jerry's presentation will do is look at these commercial and tax characteristics on a cross-sectional basis. So we'll compare the different characteristics for different types of vehicles as a basis for comparison each type of vehicle. The first there we go. This is a basic table showing the menu of business vehicles. It's divided into by three methods. One is that between corporate and non-corporate vehicles. Secondly, divided by the number of owners as a legal characteristic. In other words, some business vehicles require multiple owners and some do not. And then from the least complex at the bottom to the most complex at the top. The number of owners, members I mentioned, with respect to for business vehicles, there's a choice for, if you have one owner, you only have a choice between sole proprietorships, divisions, or corporations with one shareholder. If you have only a handful of owners, you have much more choice. You have general partnerships, limited partnerships, which we'll come to, limited liability partnerships, joint ventures and co-ownerships, and of course private corporation. All the non-business vehicles have a business vehicle or a corporate corporate law counterpart. The widely held vehicles are, of course, the public corporation and more recently the limited partnership and the mutual fund trust. Those are the broad divisions. Looking then at the limited liability characteristic, which tends to be one of the more important ones for commercial law purposes, the best limited liability protection is still the corporation. It is limited only to basically two things. One is a premature return of equity, that is, if the corporation has repaid by way of dividend or return of capital some of the money that should have been used for creditors, there can be, there's statutory provisions that require that to be clawed back at the instance of a creditor. And then beyond that, of course, there's lifting the corporate veil, which is essentially a case of fraud or other type of serious abuse. And then those are the only instances generally that the corporate veil is lifted. Compared to that, most of the other vehicles fall short. Let's go through some of them. The co-ownership agreement, as long as it's not a joint venture or a general partnership, has a fair amount of limited liability protection because you can insure against most of the known risks. And a co-ownership by its nature generally has an ownership of a large capital asset and is not an active business. And there's no concern about, there's no agency principles that operate between co-ownerships. There is for general partnerships, of course. Limited partnerships has a obviously limited liability for the limited partners, but none for the general partner. And there are some exceptions that where limited partners have to be wary of. One is, there's three. One is that the limited liability does not protect them if they participate in control of management. Secondly, there can be problems if the limited partner's name is used in the firm name and a creditor does business with it on that basis, extends credit on that basis, there will be no limited liability protection. And then thirdly, of course, there's liability for the unpaid portion of the agreed capital contribution. But apart from that, there's basically a market acceptable level of limited liability protection. The limited liability partnership, which can only be used by professional, owned solely by professional corporations. This is a combination. Sometimes you can get more by combining various business vehicles together. And so a limited liability partnership that is owned by professional corporations, and we'll go through a demonstration of why you get more limited liability protection if you do that in the next couple of slides. But just suffice to say for now that that is one illustration of where you can combine things and get more. Some protection applies to the limited liability partnership. The rules are that it protects the non-negligent partners. It doesn't protect the acts or omissions of the negligent partner, and it doesn't protect against general creditors of the firm, and also, but it does protect against the acts or omissions of those partners who are responsible for it. The professional corporation offers, like a corporation, offers some protection against limited liability partnership, but it doesn't protect against claims based on professional liability. This would be negligence, breach of contract, fraud with respect to a client, failure to follow instructions. Those aren't protected at all by the professional corporation. There is joint and several liability for the owners as well as the corporation. But it does protect against, for example, trade creditors. They're treated no better by professional corporations than any other type of creditor claim against a corporation. So there's some protection, but not much. Sole proprietorship offers no protection. Uncertain is the mutual fund trust. There's a Trust Beneficiaries Liability Act that was drafted and received first reading by the former government, and there's likely we'll see it in the near future. David Steele will speak more about trust liability, so I won't go into that. The worst, though, if you step back and look at it, is the joint venture or the general partnership, because this combines two adverse characteristics. One is the joint liability of the members combined with the agency principles, so that members of a joint venture or members of a partnership are liable for the acts of their fellow partner or member of the joint venture. This is one illustration. There's more in the paper of combining various business vehicles, but this is one that's not in the paper, and I thought I would just discuss it, just to show you how you can combine things to receive a little bit more than you could on their own. This structure contemplates a limited liability partnership. Could be an accounting firm or a law firm. The individual practitioners, there's three here. There's three individual practitioners shown on the top column, in the top row, and each one of them owns a professional corporation below that. Each one of those professional corporations is a member of the limited liability partnership. That's the structure. I'm not proposing that anybody adopt this, but just as an illustration of what you can do with combining. The next page then shows what happens if you adopt the structure. So the individual practitioner is covered by various legal vehicles surrounding him, including the professional corporation is the level above him or her, and then the limited liability partnership at a level above the professional corporation. The professional liability, starting on the left-hand side, the professional liability claims not resulting from the negligence of the individual practitioner or become liabilities of limited liability partnership, but do not affect the professional corporation. They don't go through, obviously, don't go through the professional corporation and don't go through to the individual practitioner as long as that individual practitioner was not negligent or not responsible for the negligence. Trade creditors can sue the limited liability partnership as a firm, and also the professional corporation, because the limited liability partnership does not protect against trade creditors, but the individual practitioner has a shield of its own corporation, and that shield is effective. And then, of course, the types of claims that cut right through all of these levels and can reach the individual practitioner are professional liability claims resulting from negligence of the individual practitioner himself, or based on fraud, breach of fiduciary duty, or simple failure to follow instructions. So those liabilities cut through, and those are client responsibilities. comparison of simplicity and cost of the various vehicles, the easiest and cheapest is, of course, the sole proprietorship. There can't be an agreement because there's only one person. There's a business name registration, which is good for 5 years. It costs $60 if you're using a business name other than that of the proprietor. But apart from that, there's no formalities. The next group of business vehicles that could be relatively cheap or expensive depending on circumstances are the general partnership, co-ownership, and joint venture. In all of these cases are involving a contract, and the contract can either be written or can be oral, can be implied. There's no necessity to have a written contract in these cases. Generally, there would be advisable, and there will be one, and in which case it could be quite complicated. There could also be, in some cases, like in the case of the general partnership, a requirement for a registration of the Business Names Act, which we discussed. The next level is probably the corporation with a shareholder agreement. It's similarly complex, can be complex, the shareholder agreement. We do a lot more of them, of course, so it's a lot easier to draft shareholder agreements than some of the other types of agreements that you come across. There's also a statutory fallback position, or the statute carries some of the weight, and there's oppression remedies and so forth, so it can deal with situations that you didn't contemplate. There's something in case the parties haven't agreed. Intermediate level of simplicity and cost would be limited liability partnership, because you have to have a partnership agreement and you have to have a registration, and a limited partnership because in addition to those things, you generally will need a separate corporation to be the general partner because there's no protection for that entity. So you combine the limited partnership structures generally combine two vehicles, the general partner being a corporation. And the most complex and expensive is the mutual fund trust. Name protection in descending order of protection. Notice that I put the best form of name protection as being a trademark registration, which of course is independent of any of the other business vehicles. It applies to all vehicles, and it gives you the right to use that business name or that product or service name across country. There is a distinction, but across Canada as of right. It also gives you effective civil remedies, such as injunctive relief and various other remedies. The next best would be a federal incorporation, because that gives you a right to do business under that name across Canada. You still have to do extra-provincial registrations in some provinces, but there's no name clearance issue remaining. Once you've got a federal corporation, you can do business in whatever territory or province without having to worry about whether that local registrar will allow you to operate under that name. Provincial corporation is limited, the name protection is limited only to that province. And in Ontario, it's actually very little. The province doesn't really regulate names. The worst cases are the partnership of all types. There is some protection under the Business Names Act, but it doesn't seem to go very far beyond the common law passing off action. I'm not aware of any cases under the Business Names Act. The statutory references are in the paper. The joint venture is also another case. Generally, it's not an issue for the mutual fund trust because it usually includes corporations and trademarks as assets. Flexibility. The most flexible business vehicle is the corporation. And the reasons for that are largely because the share capital structure is a separate legal person to start with. So that's a big advantage. You can devise shared capital, you can do debt financing, separation of ownership from management. It really is or not. It's about as flexible as you would like it to be. Next most flexible instruments are the joint venture, which is purely contractual. The co-ownership, which is largely contractual. The difference there is that the co-ownership generally will involve a capital-intensive asset. And depending on the nature of that asset, there could be certain statutes or rules that apply. For example, if the co-ownership involves real property, you have a Partition Act as a fallback. The same thing can happen under the Canada Shipping Act if it's a ship and so forth. So you have to look at the law governing the underlying asset. And then the general partnership is largely contractual, but again, there are some default provisions under the Partnership Act to address, such as, for example, that a partnership automatically dissolves in certain events such as death or bankruptcy of a partner. So those issues are usually addressed in a contract. Intermediate flexibility would be a sole proprietorship. The reason I say it's intermediate because you can always roll a proprietorship into a corporation. That gives you a fair amount of flexibility. And a limited liability partnership, I'm just included under that because, again, it's primarily contractual based, but there's some statutory provisions that apply. Least flexible are the mutual fund trust because of the necessary qualifications under the Income Tax Act, many of the details of which are in the paper. And then the limited partnership because it categorically separates the general partner and the limited partners and treats them as separate, gives them separate liability regimes and things that they can and cannot do. So it's the least flexible in that sense. The formalities, which are also relevant in terms of both at the formation stage and ongoing for these different vehicles, range from what is the most onerous to the least onerous. So the business corporation is probably the most onerous. You have to file articles to form. You have to file articles, pass bylaws, do a post-incorporation organization. And ongoing, you have to have annual meetings or just waive the annual meeting or have resolutions in lieu. There's an audit requirement. We have to waive the audit requirement or have one. You have to have annual financial statements. You have to file tax returns, both federally and in Ontario. You have various annual filings either under the Corporations Information Act or if you're under the CBCA, that act. So there's a fair amount of a regulatory overlay, if you call it that. From that, life gets a little easier for the different other vehicles. For example, limited partnership. I won't go through all of them, but just to give you some flavor for how this works. Limited partnership is you have to have a limited partnership agreement, unlike, for example, a general partnership, which doesn't require one. You have to file a declaration. You can lose your limited liability protection if you don't file it. And again, the ongoing requirements are usually modeled as a practical matter on a public corporation. And there's a 5-year requirement for renewal of certificate. So I won't go through all of these, but looking at the simplest one, of course, the sole proprietorship, perhaps a business name registration if there's a different name being used, and you have to renew it every 5 years. The disabilities, what can these different vehicles do or not do? And what are the fewest and most restrictive types of business vehicles? The fewest restrictions apply to a sole proprietorship because it's an individual, can do anything that an individual can do, of course, by definition. A general partnership is also has very few disabilities, but it can't hold land directly. Could hold shares in a corporation that holds land, so you have to combine 2 or more business vehicles in order to do that. Some restrictions would be a business corporation, not entitled to carry on certain professions, including law, medicine, dentistry, and accounting. Joint venture is by its nature not a continuous business. Co-ownership is an investment, not a business by its nature. And then a limited partnership cannot carry on a professional practice. The most restrictive are the 4 at the bottom. Limited liability partnership, which is only for professional practices. The professional corporation, which is only for professional practice. And again, and on top of that, there's a limitation on who the shareholders, directors, and officers can be in Ontario. Not true everywhere, but in Ontario, there are restrictions, including beneficial shareholders. The mutual fund trust is fairly restricted. It's a public vehicle only. It's capital intensive. You need a business or investment that generates significant distributable cash. These are more business considerations, but are relevant. And then, of course, you have the nonprofit organization, which is nirvana from a tax perspective, but there's no shares, so it doesn't confer any right to dividends, distribution, and winding up or voting control. So from a commercial law perspective, it's not very useful in that sense. And that's what I was going to discuss. Thank you very much. And we'll have time for some questions at the end, and particularly in the remote locations, we'll save all of the questions and the problems for the end of the session that we're doing today. Thank you. The next speaker is David Steele from Tories.
Good afternoon. I'm going to speak on business trusts or the use of trusts in commerce. So this may be a bit of a digression, I guess, in the sense that we're singling out one type of vehicle. A couple of comments that Wayne made resonate with me as a trust lawyer. The first was the comment he made that the whole issue of how to go about selecting an appropriate vehicle tends to be dealt with in a very, maybe unnecessarily, a very basic way in law school that doesn't tend to go beyond incorporation, the general partnership, and proprietorship. I think it's interesting that, of course, in a typical business law course in law school, there's almost no discussion of trusts. But paradoxically, also in a trust law course, even today, there's almost no discussion about the use of the trust in commercial settings. And I find this interesting from a practice standpoint because it's been apparent for many years that in value terms, at least, there is a great deal more wealth in trusts that we might describe as business trusts or commercial trusts than there is in comparison to the more typical use of the trust or the more, I guess, archetypal use of the trust as an estate planning tool, something for the transmission of wealth between generations in a family. This actually is more than just, I think, a matter of academic interest. It's a problem because when you're thinking about using a trust in a particular commercial setting, you're almost always forced to reason from first principles, from first trust principles. And to the extent that you're looking at case law, there is very little case law that comes to us from a commercial setting in the trust area. So you're having to sort of analogize from a family trust or a family property context to a commercial context. I mean, I think this is the fundamental challenge for using trusts in commerce. It's not a very nice fit. The fact that it works at all, I think, is a testament to the incredible flexibility of the trust idea. Now, in Wayne's remarks in surveying the different types of business vehicles, he said in a number of instances that the mutual fund trust is an inflexible vehicle, and he's right. The mutual fund trust is an inflexible vehicle because to qualify as a mutual fund trust, you have to meet certain restrictions and provisions in the tax statute. The inflexibility doesn't come from trust law. In fact, it comes from tax law, and I'm not just being defensive about this as a trust lawyer. But where do you start in talking about business trusts? And it may seem sort of overly basic, but I think it's important to start with the question of what is a business trust? Not a profound concept, but there is no technical definition of a business trust in Canadian law. I think in a lot of commercial writing, commercial law writing, you see references to business trusts, but any trust lawyer will tell you there's really no such thing. A business trust is simply a trust that you would recognize from law school being applied in a commercial setting. It covers a wide range of trusts. I mean, the term business trust, I think, is useful as a label, but it doesn't have any technical content. It covers a wide range of types of trusts, including trusts that are carrying on an active business, like an income fund type of trust, to trusts that are used in the context of pensions and benefits, to trusts that are used in the context of financing, securitizations, issuances of bonds, control of private companies, structures like voting trusts, which can be used as a substitute or an alternative to a shareholders agreement, environmental reclamation trusts. The variety is huge and is really unlimited. And again, the trust concept itself is extremely flexible. But having said that there's nothing, that the business trust idea is not something that's unique and different from any other trust, I think it's fair to say that there are attributes of a lot of trusts that are used in commercial settings that one doesn't see all that often in the context of family trusts. For instance, in commercial settings, the beneficial interests under the trust are almost always purchased for value. Whereas when you think of the typical family trust, it's usually an act of benevolence. Somebody is making a gift of property to a trustee to hold for the benefit of the class of beneficiaries. In the business trust, that's unusual. It's almost always the case that the beneficiaries, who are sometimes called unit holders or any number of different things, are purchasing their beneficial interests. So that's an important distinction, I think. There tends to be a very wide ability of trustees of business trusts to delegate their powers. They tend to contemplate a great deal of specialization and a great deal of delegation and a great deal of agency-type relationships that are sort of ancillary to the trust, more so than you would typically see in a traditional family trust. Another, I think, key distinction, although again, none of these, a family trust could have any of these features, but they're much more common in the context of a business trust, is that typically business trusts have very limited dispositive discretions. By that I mean that the beneficiaries of business trusts tend to have fixed interests. They are going to receive a fixed share of a distribution of income or capital and at stated intervals. Whereas in typical family trusts, it's quite common to see a lot of dispositive discretion and ability to pick and choose which beneficiary will receive property and how much. But, and again, another point that's not terribly profound, but I think you can never forget it if you're going to deal with trusts in commerce, is that a business trust is a trust. And having said that, in order to have a valid business trust, you have to satisfy all of the elements that you'll recall from law school for the creation of any other trust. And the first set of requirements that you need to satisfy are what you'll remember as the three certainties. The first is certainty of intention. There has to be a clear manifestation of an intention to create a trust, an intention to impose obligations on a trustee with respect to property for the benefit of some other persons or purposes. The subject matter also has to be certain. That means the trust is fundamentally a property arrangement. There has to be property for there to be a trust at all. And trust law requires that there be a clear definition of what the subject property of the trust is going to be. And then lastly, the trust has to have clearly defined objects. In order for the trustee to be able to perform the trustee's obligations properly, the trustee has to understand to whom the obligations are owed. So there has to be a clear definition of the class of beneficiaries. It is possible to create trusts for purposes as opposed to trusts for persons. But under Ontario law, at least, there's a relatively limited scope for purpose trusts. The most important category of purpose trusts are charitable purpose trusts. You cannot have non-charitable purpose trusts in Ontario. For instance, you can't create a trust, the purpose of which is to operate a business. I raise the point because I think there is a tendency to confuse motive with purpose in a trust law sense. If you look at a typical declaration of trust for an income fund, and you'll see a precedent in your materials, there's a sentence early in the trust declaration that says, this trust is an open-ended, I'll forget the language, but this trust is an open-ended, unincorporated, limited purpose trust. Well, I don't know why business lawyers insist on using those words, because every trust is unincorporated by definition. The trust isn't a legal entity. And in terms of limited purpose, they don't mean that it's a trust that's being created to prosecute a particular purpose. All they mean is that's really the motive behind the creation of the trust. It's a trust for beneficiaries. The beneficiaries are the unit holders, but it's a trust for the benefit of those beneficiaries, and it's being created to carry out a relatively limited function. The next requirement of all trusts is that there be constitution, and I'll just go through this very quickly. Constitution is nothing mysterious. It's just the vesting of the subject property in the trustee, and it can really happen in one of two principal ways, either by transfer of property from a settlor to the trustee, so it could be a gift to the trustee of a nominal amount of cash or a specific item of property, but there has to be a delivery and a vesting in the trustee of that subject property. And then the second way that trust can be created is by declaration, and that's a situation where the settlor and the trustee are effectively the same person. The owner of property is saying to the world, from this moment forward, I am holding this property for the benefit of whoever the beneficiaries are from time to time. So that's how constitution takes place. Formalities. Again, trust law itself imposes very little in the way of formality. Other statutes, like taxing statutes or securities legislation, sometimes imposes restrictions and formalities on the creation of trusts to create a particular type of trust, but trust law itself is largely free from formality. In fact, most trusts can be oral. The only trusts that require writing are trusts that involve interests in land or will trusts. Again, we've said this, but the business trust is not a legal entity. The idea of the trust is that it's a relationship or an obligation. It's a relationship between the trustee and the beneficiaries, or the trustees and the beneficiaries, or it can be conceived of the totality of obligations owed by the trustee to the class of beneficiaries. Trusts are often deemed to be entities for limited purposes. So, for instance, under the Income Tax Act, trusts are treated as entities for tax purposes. But the trust itself isn't an entity. And I think it's a critical point, because when people, if you conceive of the trust as being an entity, you will not appreciate how the liability structure of a trust works. And I think this is a real risk in commercial practice when you're using trusts. Again, a point I think I've already made to some extent, is the business trust a sui generis concept? In other words, is it something that's sort of a law unto itself? Certainly the conventional wisdom in Anglo-Canadian law is that the business trust is not a distinct legal form, it's just the inherent flexibility of the trust idea being used in a range of commercial settings. There was an important UK case a number of years ago called Target Holdings and Redferns, and I think it's worth flagging. This was a case that I think perhaps signals a bit of a new direction in the area of business trust. It was a House of Lords decision, and the facts, for present purposes, really aren't very important. But in that case, the House of Lords said that there has to be an appreciation of context in dealing with trust principles. And the House of Lords in that case said that there may be situations where what the court described as specialist rules of trust law can be jettisoned in order to give effect to the expectations of the parties and commercial realities. And so it's a tantalizing comment from a senior court that suggests that there may be some ability to break away from traditional trust principles where they don't line up terribly well with commercial realities. There haven't been very many cases decided that have cited to Target and Redferns, so it's a little unclear what the scope of the principle is. And of course, what that means is it's unclear which type of specialist rules or what specific specialist rules might be jettisoned in order to uphold commercial practice, commercial realities. But I think it's an important case. Again, I've already said, I think one of the central paradoxes of the idea of teaching trust law is that there's virtually no mention of commercial trusts, even though by sort of some statistical work that's been done in the US, over 90% of assets held in trusts are held in commercial trusts of some form as opposed to family trusts. What are the attractions of using trusts in commercial settings? Insolvency protection. If a trustee becomes bankrupt, property that's held in trust is not available to the general creditors of the trustee. That can be an important reason for considering a trust in a commercial setting. That's really at the core of the use of trusts in pension and in employee benefit situations. Flexibility in design, limited regulation. With the exception of things like the mutual fund trust and its rules under the Income Tax Act, the trust idea is an extremely flexible one. There is no statute in Ontario, for instance, that deals with the requisites for creating a trust or the regulation of trusts specifically. The Trustee Act is purely a gap-filling statute where particular issues are not dealt with in the trust instrument. For example, if you create a trust but you don't specifically indicate what type of investment restrictions are placed on the trustees, the Trustee Act will fill the void. But it's not a regulating statute, and in fact, really the most important principle in the Trustee Act is a provision that says everything in the statute yields to a contrary intention in the instrument. Trust law is inherently very flexible. There's no equivalent in trust law to the holding of meetings, to the keeping of resolutions and minutes. You can do all of these things, but they're not mandated, and there really is no case law in the trustee area that speaks to what the content of a trustee minute, for instance, might look like, or a trustee resolution might look like. Access to fiduciary rules. All I mean by that is all fiduciary relationships flow from the trust concept. The trust is where it all began. So by employing the trust as a vehicle in a commercial setting, you're in a very sort of simple and elegant way adopting all of the protections that equity has built up over hundreds of years to protect the interests of beneficiaries. So you've got this protective fiduciary regime that you can bring in very easily, and it's a fiduciary regime that is flexible as well in the sense that many of the traditional fiduciary obligations of trustees can be diluted, can be excluded entirely by appropriate drafting. So there's great flexibility. Lastly, conduit taxation. Canada and many other jurisdictions tax trusts on a flow-through basis. In other words, the trust gets a deduction for income that's distributed to beneficiaries, and there's tax in the beneficiary's hands. So there's conduit taxation. I'm going to skip this slide. Actually, sorry, a number of these slides seem to be ones from another presentation. Sources of trustee obligations. There are really three. There's the trust instrument itself. The trust instrument goes under a variety of different names, including declaration of trust, trust indenture, deed of trust, trust agreement. By whatever it's called, this is really where you start. Because again, the statute and the equitable rules that make up trust law, almost all will yield to a contrary intention being expressed in the trust instrument. So really the trust instrument is where you have to start. Again, you've got a body of equitable rules and common law principles that also are important in understanding trustee obligations. But unfortunately, again, most of them don't come from a commercial setting, so you have to proceed by analogy. Lastly, statute. Again, there may be specific types of trusts that are quite heavily regulated, and so statute may be important, but there are no sort of general trust law statutes in this jurisdiction that will have a big impact on using trusts in commerce. I'll go through these very quickly. The primary obligations of trustees, we're all familiar with these. Duty of ordinary skill and prudence, duty of loyalty, duty to adhere to the terms of the trust instrument, to avoid delegation, and to maintain an even hand. These all really flow from the fiduciary nature of trusteeship. These are the default protective regime that you get simply by using the trust idea. Again, I think the most important of all of them is the duty to adhere to the trust instrument, because again, many of the other core duties can be diluted or excluded entirely, including, for instance, things like the even hand obligation. As you know, that's the duty on trustees to treat all beneficiaries in a fair and equal way. That duty can be completely displaced by appropriate wording in a trust instrument. So again, you really have to start with the script, and the script is the trust instrument. A couple of words about protecting the trustee. There are a number of ways in which you can protect the trustee. One important way is to limit the trustee's powers and discretions. And again, an interesting feature of many business trusts is that they tend to not only have minimal dispositive discretion, but in many forms of business trust, there tends to be relatively limited discretion in administrative matters as well. If you think of something like a securitization trust, for instance, the accounting profession has coined the term brain-dead trust to describe these types of structures because everything is dictated to the trustee. The trustee has very little scope for decision. The trustee has a role to play but doesn't have a great range of choice. The more you limit the range of choice of the trustee, the less room there is for the trustee to commit a breach, to run afoul, and to get into trouble by making poor decisions. Secondly, exculpatory clauses. There is considerable scope, I think, to reduce the trustee's standard of care. It's not entirely clear how far you can go. There's conflicting authority in Canada and the UK right now. In Canada, it would seem that it may not be possible to exculpate for gross negligence, whatever that may mean, and it's clearly not possible to relieve a trustee for a willful breach, a deliberate breach of trust that the trustee knows and expects to be harmful. Beneficiary liability in business trust. This really takes us to, I think, two key issues that I want to talk about just before I finish up here. This has been very much a hot topic, the issue of beneficiary liability in business trust. The issue is to what extent can a unit holder, for example, in an income fund or an income trust, be liable for amounts in excess of the person's investment in the fund. Again, I think it's important here to sort of go back to general trust principles. The basic rule is that subject to the terms of the trust instrument, beneficiaries do not have personal liability. When somebody talks about a business trust, for example, entering into a contract, it's really a shorthand way of saying that the trustee of the trust is entering into the contract. The trust isn't an entity, so the trust can't acquire rights and obligations. When the trustee enters into a contract, the trustee acquires the liability and the obligation, and it can't be visited on the beneficiaries in the typical case because the trustee doesn't contract as agent for the beneficiaries. The trustee acts as principal. There are really two situations, though, where a concern can arise about liability flowing through to beneficiaries of a business trust or any other type of trust. Let me talk about one which isn't in the overhead first. There is a trust law principle that's referred to as the rule in Hardoon and Balilius, and it's discussed in my paper in the materials. It's a somewhat uncertain rule that does suggest, though, that there are cases where if you have a trust where all of the beneficiaries are adult and capacitated, that the beneficiaries may have a duty to or an obligation to indemnify the trustee for amounts that the trustee, obligations that the trustee has incurred where the trust fund is not adequate to meet the trustee's obligations. However, although this rule is out there as a bit of a pitfall, it really doesn't have, I think, a huge significance for trust in a commercial setting. Not because the rule couldn't apply, I think it could, but for two reasons. First, the case law is very clear that you can exclude this indemnity, this obligation of beneficiaries to indemnify the trustee with clear language in the trust instrument. And that is universally done. Any income fund you look at, any mutual fund trust you look at will include a provision indicating that the trustee has no rights of indemnity against the beneficiaries, and there doesn't seem to be any question that that's effective to cut off that potential risk to the beneficiaries. Secondly, the case law indicates that even without a provision like that, third-party creditors, obligations that the trustee incurs to third parties, the third parties won't be subrogated to any indemnity rights that the trustee has against the beneficiaries in any event. So, again, the practical significance of this in commercial settings is relatively limited. The real concern about beneficiary liability arises in situations where you have, arguably at least, not simply a trust relationship between the trustees and beneficiaries, but also arguably an agency relationship between the trustee and beneficiaries. And The extent of this agency problem, or the ability of agency principles to overlap with trust principles, I think in Canada at least, is not presently perfectly clear. There isn't any doubt that there are cases where you can have both a trust and an agency. And the case that everyone agrees about is the so-called bear trust. And a bear trust, again, isn't a term of trust law art, but it's used as a convenient way to describe a trust where the trustee has no independent powers or discretions. The trustee is simply a repository of title to some asset for the benefit of the beneficiary. The trustee doesn't have any ability to make decisions. In that case, if the trustee enters into a contract, Canadian case law indicates that the courts are prepared to find that while there is a true trust in the sense that there's a separation of the legal and equitable estates, there's also an agency relationship. So the trustee in that bear trust situation will contract with third parties as agent for the beneficiaries, who are the principals, and there can be a flow through of liability. Everybody agrees on that situation. But again, most trusts used in commercial settings are pretty clearly not bear trusts. If you think about something like an income fund, and again, you'll see the declaration of trust in the materials, the trustees are given fairly extensive powers and discretions, at least of an administrative nature. So it's pretty clear that it's not going to be found to be a bear trust. The risk is that a court may extend this agency, this overlapping of agency principles with trust principles in some kind of a wider context. And it's been suggested by one commentator, Professor Robert Flanagan, who's also referred to in my paper, that there may be cases where so much control is exerted by the beneficiaries over the trustees in the administration of the trust that it may tip the scales toward a finding of agency. And he looks to some U.S. case law involving trusts in commerce to advance this theory. And he says, for instance, he's not precise on which particular powers will cause a problem, but he says, look, a combination of powers like the ability to remove and replace trustees, that if, again, these are powers given to the beneficiaries, an ability or requirement that beneficiaries ratify certain decisions that are to be taken by the trustees. These types of things in combination may tip the scales to a situation where you have both a trust relationship at the level of property law, but you also have an agent-principal relationship and liability can flow through. I think that the better view, certainly from a trust lawyer's perspective, is that Professor Flanagan got it wrong. And there really is very little indication that Canadian courts will adopt this sort of wider control test and that it would be applied in the context of things like mutual fund trusts. But it's still a risk, and it's a risk that has affected the marketing and the marketability of units in business trusts in Canada. As Wayne mentioned, there is a statute, or at least there is a draft bill, a private member's bill that had its first reading in December of last year. It's part of my materials. That's called the Trust Beneficiaries Liability Act. This is a fairly modest attempt, I think, to address this issue and effectively to put beneficiaries of a very limited category of trusts. These are trusts that are offering securities to the public and which are governed by Ontario law, to put them on the same footing with shareholders in business corporations. So it's an attempt to address this liability concern that I think a lot of us feel is, at least in trust terms, pretty academic anyway. As a private members bill, I really don't have a good sense of whether this is likely to ever become law, but there's certainly a lobbying effort to make it so. The last topic, and I hope I've run over time here, is that I wanted to talk about just briefly, and we can pick it up in the questions later, is an issue that I think is both complicated and very important in business trust practice, and that is the issue of recourse to the assets of a business trust by creditors of the trustee. And here I'm talking about creditors of the trustee that the trustee is dealing with in the course of acting as trustee. I'm not talking about personal individual creditors of the trustee. I'm talking about a situation where the trustee is going out and entering into a contract in the course of administering the trust and the liabilities incurred. Again, I think it's important that you go back to basic principles, and this is again an instance where I think it's critical to recall that even though when you look at a lot of the contracts that are drafted by commercial lawyers, they will describe the trust as being the party to the contract. Remember, the trust isn't a legal entity. It can't incur obligations. The relevant actor is almost always going to be the trustee. It will never be the trust. And again, it's important as well to realize that except arguably in the case of bare trusts, as we've just talked about, the trustee contracts, incurs obligations as principal and not as agent for the beneficiaries and not as agent for the trust, because again, the trust has no legal personality. The second point, and again, I'm sure this is familiar to you from law school courses on trusts, but all trustees have a right of indemnification for obligations that they incur properly in the course of administering the trust. It's never been the case that the trustee goes out and acts as principal and incurs liabilities in the course of administering the trust and isn't entitled to be held harmless out of the trust fund itself. Being a trustee would be completely unappetizing if that was the case. So trustees are always entitled to indemnity so long as the obligations that they're incurring are proper in the sense that they're authorized by the trust, proper in the sense that they represent an appropriate exercise of their judgment and their fiduciary duties. So the conventional sort of Anglo-Canadian thinking about recourse issues has said that, look, if you're a third-party creditor who's entered into a contract with a trustee, your only ability to reach the trust fund is going to be by way of being subrogated to the trustee's own right of indemnification. So if in some way the trustee has lost its rights of indemnity against the fund, and that could happen because the trustee has become indebted to the fund in some completely unrelated transaction, the sort of conventional wisdom would say the third-party creditor is in a real bind because the third-party creditor can't stand in any better position than the trustee could because it's a subrogated type of claim. And so if the trustee's personal assets, personal non-trust assets aren't adequate to satisfy the claim of the third-party creditor, there's a problem. There are situations, though, in which direct claims will, by direct claims, I mean claims that are that can be realized directly against the assets of the trust fund, non-derivative claims, will be recognized. And I think the scope of these exceptions to the subrogated claim thinking of traditional trust law is far from clear. The law in terms of trustee recourse issues, I think, is not very well developed in Canada. It's not very well developed in the United Kingdom. It's quite well developed in the US, and it's also quite well developed in Australia. But each of these direct claim exceptions that I'm going to refer to do have recognition. There is case law and other recognition of these exceptions in Canada and the UK as well. The first is a restitutionary claim, and I'll just speak to this very quickly. If a third-party creditor has entered into a contract, for example, with the trustee, and even if that contract was one that the trustee wasn't permitted to enter into under the terms of the trust instrument, if a benefit has been conferred on the trust fund by virtue of that contract, if the trustee, even though it was an ultra-virus contract, has used a product, for example, that was obtained under that contract and somehow benefited the trust fund, then under restitutionary principles, under theory of unjust enrichment, the third-party creditor will have a direct claim against the trust fund to the extent of that enrichment. It can be helpful in some cases, but it's a limited remedy in really two ways. First, that it's only going to be available to the third-party creditor to the extent that there's no other adequate remedy. But more importantly, it's only going to be the extent of the recourse, the extent of the recovery is going to be limited to the amount of the benefit conferred on the trust fund rather than the extent of the loss, because again, it's a restitutionary remedy. The second exception is what I've called the trust instrument claim. By that I mean where there is an express provision in the trust instrument indicating that people who contract or incur obligations in dealing with the trustee will have direct recourse to the trust property on a non-subrogated claim. The case law suggests that that will be respected, and a direct non-subrogated claim will be available. But that direct non-subrogated claim will only be available where the contract or the obligation was properly incurred. In the case of the restitutionary claim, it doesn't matter whether the obligation was properly incurred by the trustee or not. In the trust instrument type of claim, it has to be properly incurred. Contract-based claim, it's a lot like the trust instrument claim, except when we're talking about the contract-based claim, what we're saying is that the contract between the trustee and the third-party creditor expressly provides for a direct right or recourse to the third-party creditor. So again, as a drafting matter, if you're acting for the third-party creditor, important to see that there's clear language in your contract providing for this type of recourse. Again, happy to talk about these issues further in the questions. I think I've run over a little bit, so I'm going to cut it off here. Thanks.
How do I get rid of this?
Okay, thanks, David. At the beginning of your binders is the paper that Wayne and I have prepared. Part 4 of the paper and the checklist at the end differentiates the tax treatment of the various vehicles in some specific detail, although I'd caution, as you will readily appreciate, that the tax treatment is only an overview, particularly of the taxation of corporations and partnerships, for which there are whole separate books. Also, as Wayne mentioned, while the paper discusses the vehicles one at a time, from a tax perspective, the choice of vehicle rests on a desire for tax efficiency, and you can analyze that based on a variety of criteria. So that's what I'd like to do in the presentation. Before I do that, however, when I was researching my part of the paper, I came across a paragraph in another paper, and maybe this is something that best comes from the tax lawyer in any event. What it says is, however, in practice, the choice of vehicle will be dependent on a broad range of criteria, including those which should be characterized as predominantly legal, practical, personal, economic, or business considerations. Rarely will it make sense to make any choice which has its justification only in tax efficiency. It's never a good idea to make such choices where they conflict with the personal expectations and objectives of the client. Our job is to try to arm our clients with the best possible advice and to educate them as to what are in fact appropriate choices. Sometimes what is best isn't the most effective tax solution. I think that's important. When you're considering this, it's very easy to be seduced by the tax efficiencies, but obviously the important thing is to listen to your client and understand what it is they're really after. Having said that, I've probably now lost my membership in the Canadian Tax Foundation, but we'll proceed. The first criterion I'd like to look at is tax neutrality. The maximum individual tax rate in Ontario for 2004 is about 46.4%, assuming that you ignore the about to be imposed employer health premium. What you want to do in terms of achieving tax neutrality is to avoid double taxation or more onerous overall taxation than that maximum individual tax rate. Now, several of the vehicles, proprietorships, partnerships, joint ventures, can be characterized for tax purposes as flow-through vehicles. That is to say, the results from the vehicle immediately find their way onto the income tax returns of the participants. So they're completely tax neutral. A trust is perhaps a more convoluted tax neutral vehicle. You have two choices here, as David mentioned. A trust has income, but then it's entitled to a deduction to the extent income is paid or payable in the year to a beneficiary, and then the income is taxed in the hands of the beneficiary. Alternatively, the trust can, if it's permitted under the trust instrument, retain the income, in which case, if it's an inter vivos trust, it's taxed at the maximum marginal rate, and subsequently capital distributions can be made to the beneficiaries generally on a tax-free basis. So again, the trust can be a conduit vehicle. The vehicle where you run into problems with tax neutrality is the corporation. While the investment income of a Canadian-controlled private corporation can generally be said to be integrated, that is to say, you get more or less the same tax result if you earn investment income like interest as an individual as you do if a corporation earns the interest income and then pays tax on it and then pays the income out to you as a dividend. The same cannot be said for business income. Where a Canadian-controlled corporation has business income in excess of the small business deduction limit, or where a public corporation has any income at all, if it earns that income and then pays dividends out to the beneficiaries, the maximum tax rate is, the total overall tax rate is about 56%, some 10% higher than the maximum individual tax rate I mentioned before. One historical and effective response to this in the private company context is to pay bonuses to the owner-operator of the business so as to get the income of the corporation down to the small business limit. Now, historically, the Canada Revenue Agency, as it's now called, has had an indulgent policy toward the deductibility of bonuses paid to owner-operators of a Canadian-controlled private corporation where they're actively involved in the business. There's normally a limit of reasonableness on the deductibility of expenses, but revenue, as I say, turns a relatively blind eye in this case. A recent development, however, is that at the 2003 Canadian Tax Foundation conference, revenue officials indicated that they were no longer automatically going to apply this policy to certain types of income, and in particular where the income from which the bonus was paid emanated from sales out of the ordinary course of assets of the business. So if you sold off a division or sold off assets out of the ordinary course, revenue wants to look at that situation and will still grant deductibility if it's satisfied there's nothing untoward, but it has to be done in the context of an advanced income tax ruling application. The other response to the lack of integration in the corporate context, well, I guess there's historically one, is just not paying dividends out to the shareholders and let them get their gains through selling their shares in the secondary market. The more recent response, however, is the income trust phenomenon, which basically uses deductible interest as a means of siphoning off the income of the corporation into the hands of the trust. If you think of it, this technique, which is described in one simple form in the paper, is much like the deductibility of bonuses. Find a way of getting a deductible expense and then use that to get the income of the corporation out to the owners without the corporation being subject to tax, and then you've only got the one level of tax in the hands of the recipient. The second criterion to be looked at in terms of tax efficiency is tax savings. And there's really three issues here I want to raise with you. Conduit vehicles, obviously there's no tax saving because, as I said, a proprietorship, partnership, joint venture, the results immediately flow onto the income tax returns of the owners, so it's neutral, but there is no tax saving. Just as the corporation is the one vehicle that generates the absence of tax neutrality in the negative sense, it can also generate positive tax savings where you're eligible for the small business deduction, where you have active business income earned by a Canadian-controlled private corporation. In that case, the tax rate on active business income is 18.6% in the corporation. If you pay dividends of the after-tax income to the shareholders, the maximum individual tax rate, taking into account the gross up and dividend tax credit, is about 31.3%, which combines to a net rate of 44%, which is some 2.3% less than the maximum individual tax rate. So you can actually get a tax saving by using a corporation if you limit its income to the small business limit. The small business limit for 2004 is $250,000 of income. The federal budget in March of this year announced that the maximum for next year would be $300,000. Because there are these tax savings, there are, of course, a number of rules in the Act designed to limit access to the small business deduction. The most notable of these are the associated corporation rules. If you have associated corporations, that is corporations essentially under common control, it's a much more complicated definition than that, but that's the essence of it. Then they have to share one small business deduction per year. You cannot multiply the deduction by having a partnership. The income of the partnership is taxed in the hands of the partners effectively as if the partnership had a small business deduction itself, and there's an example of that in the paper. And finally, to keep the benefit of the small business deduction to smaller corporations, there are clawback rules in both the federal and provincial legislation. In the federal legislation, it's tied to liability for tax under the so-called large corporations tax, which is essentially a capital tax. So once a corporation has a sufficient level of capital, it will no longer be eligible for the exemption. Provincially, the exemption is clawed back based on the income level of the corporation, and I think once the corporation has about $1 million or so of income provincially, then the benefit of the small business deduction is lost. Capital gains exemption, another benefit in favor of a corporation. This certainly creates a bias in favor of using a Canadian-controlled private corporation because the shareholders can sell their shares, and the first $500,000 of gains are not subject to tax. There is a two-pronged test in order to be eligible for the capital gains exemption. Firstly, the shares have to be held by the vendor or persons related to the vendor for a minimum of 2 years. And secondly, there is an asset composition test, essentially to the effect that 50% of the assets of the corporation have to be used in an active business for the previous 2 years, and 90% of the assets have to be so used on closing. There's another a little more convoluted rule where a holding corporation is used that's designed to prevent diminishing the asset rule through the use of multiple corporations. Now, all is not lost, however, for proprietorships and partnerships in that the first test, the 2-year holding period test, is waived if you transfer partnership assets or proprietorship assets into a corporation and then immediately sell them. So as a planning point, if you have a partnership or proprietorship and you're going to sell the business, you would want to first roll those assets into a corporation and then sell the shares. You still, of course, have to meet the asset composition test that I just described. There is no capital gains exemption for the disposition of trust interests, but as I'm sure you're aware, trusts are very useful vehicles for multiplying access to the small business deduction. A trust can hold shares of a corporation, and each beneficiary is entitled to access the capital gains exemption once the shares are sold by the trust and the proceeds are flowed out to the beneficiaries. Third type of saving that can be achieved is through the application of losses against other sources of income. Again, for the flow-through vehicles, you have an immediate set-off. If you're a proprietor and you lose money, but you have income from another source, the two can be set off against each other. Partnerships, essentially the same rule. The only caution here is that if you are a limited partner, the amount of losses that you claim is limited to the amount that you have at risk in the partnership, which is a defined term, and that's more particularly described in the paper. Losses of a joint venture, again, can be offset by the joint venture against other sources of income. Trusts are a little more complicated. While a trust can flow out income to the beneficiaries, it technically cannot flow out losses. However, it is possible for a trust to deem certain types of income in future years not to be distributed and then offset prior years' losses against that income that the trust is deemed to have retained, so that in effect the trust can utilize its prior losses and still distribute income out to the beneficiaries. So while it's not as simple as with a proprietorship or a partnership, a trust can effectively get itself into the same position. Corporations are sticky vehicles in this sense. As you know, unlike the United States, we do not permit consolidated returns in Canada. Corporations cannot transfer their losses out to beneficiaries, nor can corporations within a corporate group file consolidated returns to set off the profits of one corporation against the losses of the other. However, generally speaking, if these types of transactions occur within a group of corporations that are affiliated for tax purposes, again, there's a definition of that, but essentially under common control, then revenue is quite indulgent about permitting a variety of transactions to occur which will utilize losses within an affiliated group. For instance, a profitable corporation can transfer a business to a loss corporation so that the profits from that business in the future can use up the losses. The most common technique, I think, is to manufacture interest income in the hands of the loss corporation and manufacture an offsetting interest deduction elsewhere in the group through financing transactions where one corporation lends money to another. And of course, it's possible to merge profitable and loss corporations through the use of amalgamations or winding up. Losses, non-capital losses can be carried back 3 years and forward 7. The bit of news here is that the March 2004 federal budget proposes that for taxation years ending after the budget, losses can be carried forward for 10 years. The Ontario budget, which was announced a week or two ago, also indicated that the province would conform its loss carry forward rules to the federal rules. Tax deferral. Again, for flow-through entities, there is no opportunity for tax deferral because the results are immediately reported by the owners. It used to be, if you were a lawyer, for instance, until 1995, you could obtain a modest deferral by selecting a year-end for your proprietorship or partnership business that was other than the calendar year, let's say January 31st. So the 11 months ending December 31st in year 1 would not be reported in year 1, but would be reported in year 2 when the fiscal period of the partnership or proprietorship ended. That was stopped in 1995, so there's no deferral there. Trusts, retaining income in a trust does not help you because a trust is taxed at the maximum marginal rate. Again, corporations seem to be really a mixed bag. There's an advantage here by retaining income in a corporation. The maximum tax rate for, say, a public corporation is about 36% this year. That's some 10% lower than the maximum rate for individuals, so there's a deferral opportunity by retaining income in the business. Where you're eligible for the small business deduction, the deferral is even more dramatic in that the tax rate is 18%, so you get about a 28% deferral. Other methods of obtaining deferrals, if you have a corporation, for instance, that has a calendar year end, the corporation could declare a bonus in favor of the owner of the business in year 1. Because the corporation is on an accrual basis of accounting, it can deduct that bonus in year 1 even though it hasn't paid it. There is a requirement, however, that the bonus has to be paid within 180 days after the end of the year, or it ceases to be deductible in year 1. The proprietor, on the other hand, would be getting this money as employment income, and since employment income is taxed on a cash basis, the owner would not be taking that amount into income until year 2. So you can get a 1-year deferral in that situation. Similarly, while partnerships generally have to have a calendar year end where it's a corporate partnership, that's not necessarily the case, and you can achieve a deferral for corporations who are partners by picking an appropriate year end. So for instance, if the partnership had a calendar year end and the corporation selected a November 30 year end, then you would get a deferral of 11 months of the partnership's income into the next year of the corporation. There are some rules relating to the computation of income that differ between amongst the various vehicles. For instance, interest charges and property taxes on vacant land are generally not deductible. In the case of a corporation, there is an ability, however, to deduct interest on a loan of up to $1 million if it's a principal business corporation engaged in real estate development. Similarly, the investment tax credit rates varies depending on the type of vehicle. An individual or partnership or a trust are generally eligible for 20% investment tax credits on scientific research and development. In the case of a Canadian-controlled private corporation, that rate can be as high as 35%, and the credit is actually refundable, so you don't need income necessarily and tax liability in order to recoup the credit. There's some other examples of that that are described in the paper. Capital structure and income splitting. Again, proprietorship is probably the worst. You can't do a whole lot of income splitting other than employing a relative, I suppose, as an employee. Partnerships potentially are vehicles for income splitting or for having a complex capital structure. The one chilling factor here is Section 103 of the Income Tax Act that says that if the if the allocation of income in a partnership is considered by the minister to be artificial, the minister has the ability to reallocate the income amongst the partners. So using a partnership for estate planning purposes, for an estate freeze, is somewhat problematic in light of this provision. Now, you might ask yourself, of course, well, if I can do an estate freeze in the corporate context and that's okay, then why would somebody consider it to be artificial in the partnership context? And that is certainly a good argument, but as I say, Section 103 is there, and I think it does have somewhat of an inhibiting effect. Trusts are obviously excellent vehicles for estate planning in terms of holding shares in corporations and permitting a variety of interests that way. Corporations are, of course, absolutely the most flexible vehicle in terms of the capital structure that can be created. You can have common shares, voting and non-voting. An infinite variety of preferred share conditions can be used. I just caution here that there are a number of detailed rules in the Income Tax Act relating to the taxation of preferred shares in particular. And when you're setting up a share structure in a corporation, this is an area where the help of a tax specialist is absolutely necessary. A corporation can, as I say, have an infinite variety of share conditions. The proprietors can loan money to the corporation. They can be paid salaries. They can license intellectual property of the corporation and be paid royalties. So there's a wide variety of interests that can be had in the corporation. Finally, when you're looking at a vehicle, the other question you have to ask yourself is, well, if I don't like it or I want to change it later, is it reversible? Can I change it into something else? Well, a proprietorship, yes, you can roll the assets into a partnership under subsection 97 brackets 2 of the Act, or into a corporation under 85(1). And as I mentioned before, this is something you would want to do in terms of making sure you get the capital gains exemption when you sell the proprietorship business. Partnerships have similar rollovers. You can transfer a partnership into a proprietorship using 98(5) of the Act. There are two ways a partnership can be, in effect, incorporated. Firstly, you can transfer the assets of the partnership to a subsidiary corporation of the partnership and then distribute the shares to the partners. There's a rollover in the Act there under sections 85(2) and 3. Alternatively, you can distribute the assets out of the partnership to the partners under 98(3) tax-free, and then the partners can then roll the assets into a corporation under 85(1). So there's lots of flexibility there. Joint ventures can be incorporated. They can be converted into partnerships. Public trust vehicles are perhaps a little less flexible, and David has alluded to that. And finally, the corporation is, of course, the most difficult in some respects. You can certainly roll assets of one corporation to another. You can roll the assets into a partnership or division, or you can have a division. You can transfer the assets to a joint venture. What you have, and you can also do a butterfly reorganization, essentially taking the corporation and like an amoeba, cell dividing it into two corporations on a tax-free basis. What you can't do without some difficulty is get the assets back to the individual shareholders on a tax-free basis. To the extent that the individual has, there's paid up capital in the individual shares, that can be transferred tax-free back to the individual, but anything above that is treated as a dividend, and any distribution of assets in specie out of the corporation will involve a realization at fair market value of those assets when they're distributed to shareholders. So once you've put it in the corporate form, it's you can move it around within the corporate form to other corporations, but it is more difficult having incorporated to extract the assets without there being any tax cost. That, I think, concludes my presentation. Wayne, I think, has some wrap-up comments. Thank you.
Just on this part of I just want to leave you with two thoughts as we conclude this part. One is that the market has moved towards alternative business vehicles very decidedly in the last decade or so. You're seeing more ULCs, LLCs, business trusts, LLPs, professional corporations now than ever before. So the alternative business vehicles has received a lot of marketplace attention. In contrast to that, the law has fallen behind. The corporate laws have received a great deal of attention. For example, in 2001, the CBCA went through a major overhaul. The OBC is relatively good shape. It's a little bit behind the CBCA. For example, we don't have any ULC legislation at the federal level anywhere other than Nova Scotia. Financial assistance provisions of the OBCA were emasculated but not repealed, and there's still some directorship issues that haven't been addressed in the OBCA. So the corporate laws are in relatively good shape, but in contrast to that, the laws are affecting non-corporate vehicles, alternative business vehicles, are in a very sad state of repair, considering their use today in the marketplace. For example, just a few examples, the Partnerships Act and the Limited Partnerships Act have basically not been changed since the 1890s. And they were even based then by Mackenzie Chalmers on a partial codification of common law that existed at that time, most of which was in the mid-19th century. Partnership, for example, is still not treated as a legal person. The limited LLPs are just a patch on the Partnership Act. There's the case law on joint ventures is still very much underdeveloped. There's no, as David mentioned, there's no specific legislation governing business trusts. The USTA only dealt with a very narrow aspect, which is limited liability protection for investors in a publicly traded business trust. But very fundamental issues affecting business trusts have not been addressed at all, such as governance issues. Marketplace is moving in that direction, but these issues are being ignored. Unlike the United States, where in states like Delaware and Maryland, we see comprehensive business trust legislation. I won't go into all the details. Securities transfer. This is the law that governs the transfer and pledging of interest in various business vehicles. Shares, for example, in corporations, but also units and trusts. It's completely unregulated except in the corporate law field. So we don't have anything like revised Article 8 of the Uniform Commercial Code in the U.S. There is a draft Uniform Securities Transfer Act, but we're still not there yet. So this is something else that's fallen behind. Finally, the Companies Creditors Arrangement Act, governing one method of dealing with arrangements for insolvent companies, only applies to companies, doesn't apply to, on its face, doesn't apply to anything other than a company or a corporation. So business trusts and LLPs, LPs, limited partnerships, are not expressly addressed under the CCAA, although there is a case called Lendorf General Properties where Farley managed to still make it applicable to an LP, but whether that's right or not remains to be seen. But so the laws affecting these alternative business vehicles are in a sad state of repair, is my conclusion. Thanks.
All right, we have a dinner for you outside, I think, and we'll try to get everybody out the originally scheduled time by condensing the Q&A and the hypothetical session, maybe get you out a few minutes late. And we'll take, say, 10 to 15 minutes now and ask everybody to be back around 6:30 for the resumption of the session. Thanks very much. Thanks, guys.